Our next presenter, Miss Sarah Bowerly-Dansman, is a nationally renowned expert when it comes to CFIUS. And thankfully, we actually have her in Indiana at Indiana University as an assistant professor for international relations. So she's going to be talking a little bit about the CFIUS process when it comes to foreign direct investment. So please join me in welcoming Sarah.
Thank you again, Colin, and all of the panelists, as well as those of you in the audience. I'm going to talk for about 15 minutes, maybe a little bit less, so hopefully we'll have a lot of time for question and answers at the end. So what I'm going to do in my short time is overview why U.S. businesses, foreign investors, and economic development organizations all need to incorporate CFIUS into their planning. I'm then going to overview the U.S.'s investment screening mechanism and what it is, what it's looking for, how it's structured, and also discuss the filing process. Although I should be very clear that I am not an attorney, and you should not consider this presentation to be sufficient or any legal advice around how to engage in a CFIUS filing process. And as I mentioned before, I want to limit my remarks so that there is plenty of time for questions. So first, let me make a case for why you should care about investment screening. So the first is that investment review in the United States now covers a much larger portion of inward investment than it did even just a few years ago. So those of you who know much about CFIUS will know that it mostly covers mergers and acquisitions, and basically any merger or acquisition that involves a U.S. business as the target and a foreign company as the acquirer will be covered through a CFIUS process. But now there are some other types of investment that are also included in CFIUS, or are subject to a CFIUS review process. The first is non-controlling but non-passive investment in what are called TID businesses, which stands for critical technology, critical infrastructure, and sensitive personal data, which through those definitions actually include a lot of economic activity in the United States. Additionally, beyond that non-controlling, non-passive investment, there's also an expansion of CFIUS review over real estate that includes the buying of real estate or leasing of real estate if it confers upon the leasee a number of rights, and this deals with co-location issues. So there's actually a place that you can look to see kind of where in the US real estate creates a CFIUS filing component. And a lot of this has to do with co-location with military bases. Indiana has 3 bases, and so there are kind of certain areas in Indiana in which real estate filings for CFIUS matter. The second kind of reason why you should care about investment screening if you're an economic development organization is that you need to consider how a CFIUS might affect your development plans, because it's important to understand what kinds of investments are likely to be scrutinized as you're considering what types of investments to try to attract. And then from a company perspective, it's really important whether you are the potential target or acquirer to understand what your filing obligations are, as well as your legal risks, so that you go into any kind of investment negotiation fully understanding what you're getting yourselves into. And then finally, it's just much better to be proactive about filings to build trust. So if a company is clearly operating in an area that could generate national security risks from the perspective of the US government, the government might interpret a failure to file as an attempt to fly under the radar or evidence that the acquirer does not take regulatory obligations seriously. And so it's just better to build trust by understanding the statute and the regulatory process really well, so that you can file when necessary, so that you don't end up kind of communicating to the government that you're kind of not taking the regulation seriously. Okay, so now that I've convinced you that you need to learn more about investment screening regulation, I want to overview how investment screening or investment security review works in the United States. So the screening mechanism in the United States is called the Committee on Foreign Investment in the United States, or CFIUS. And CFIUS was created in 1975 by executive order and has since undergone 3 major regulatory changes, all of which have expanded the scope and strengthened the committee's authorities. So CFIUS operates as an interagency committee chaired by the Department of Treasury. Here it is in the center of this circle. And then there are 8 other federal agencies that have a voting seat on the committee. And these range from the Department of Defense to the Department of Commerce, State, and several other agencies kind of within that realm of both foreign policy and also economic policy. So this whole of government approach is designed to bring many voices, perspectives, and government equities to the table. And that is quite different from other countries that tend to host their screening authority in one ministry, which may look at the transaction only from a military or only from a commercial perspective. So the US, this whole of government approach ensures that for each transaction, you have both the kind of the military foreign policy concerns at the table, but also the commercial and technological concerns at the table as well. And in practice, the committee mostly operates by consensus, then majority vote. So the committee is tasked with reviewing covered transactions for possible national security risks. So CFIUS can only intercede in an investment if they find a national security risk that arises from the transaction. It is not a screen for economic concerns or competition concerns, etc. A transaction is covered if it targets a US business, and the transaction, if concluded, would provide a foreign person with control over the US business. Although since early 2020, CFIUS also has jurisdiction to review non-controlling transactions if the US target is considered a critical technology, critical infrastructure, or sensitive personal data business, and if the foreign investor gains some kind of special non-passive rights for their non-controlling investment. And additionally, as I mentioned on the last slide, there's also now a way in which a real estate transaction could also be considered under CFIUS jurisdiction as well. So CFIUS then reviews the transaction to determine if it presents a national security risk. And if the committee identifies a risk, it then determines if it is possible to mitigate that risk through a national security arrangement with the parties. And if mitigation is deemed to not be possible, then CFIUS communicates this to the transaction parties. And those parties can decide to withdraw and abandon the transaction. If the parties choose not to abandon the transaction, CFIUS refers the matter to the president, who has the authority to prohibit the transaction through a presidential order. So only the president has the ability to actually prohibit a transaction or require a divestment of a investment that was first made and then subsequently went through the CFIUS review process. CFIUS itself does not have that authority, although oftentimes firms, if they find themselves in the position where CFIUS would be referring the matter to the president, will instead decide to withdraw and abandon the transaction because in doing so, they could keep that information confidential. If it goes to a presidential determination, that becomes public knowledge. Presidential determinations are non-judiciable, meaning that parties cannot challenge the national security risk analysis that undergirds a presidential prohibition in court. So this table, which I hope that you can see, I've compiled from publicly available sources, and it provides details on CFIUS activities from 2005 to 2018. And you will see that presidential blocks are exceedingly rare. If I updated this to 2020, which recently the the committee released information for 2019 and 2020, this really wouldn't change all that much. Presidential blocks are exceedingly rare. There have been only 7 blocks in the history of CFIUS, but there has been a steady rise in transactions mitigated and transactions abandoned in recent years. CFIUS reviews a small but growing minority of total cross-border merger and acquisition deals each year, and only about 5% of all deals are withdrawn, mitigated, or blocked through committee action. So this is an important regulatory body that you have to understand, but it's also, not going in and sort of touching every single transaction happening in the US economy. I want to highlight a few key features of the CFIUS process. So first, while CFIUS has received much more attention from politicians and the press in recent years, it really is supposed to be a tool of last resort. So when a president issues a prohibition, the order always states that there are no other provisions in law that can adequately mitigate the national security risk. So CFIUS is best seen as a stopgap measure to protect national security when existing authorities are inadequate, often because there's an assessment that the risk that arises from the transaction is novel. So the US government really does prefer to lean on regulatory measures that are clear ex ante and that apply broadly rather than are applied on a case-by-case screening, because that is just better for the operation of like a open business environment in which firms can kind of adequately understand risk and it reduces uncertainty. So some of the measures that that the U.S. government would kind of try to use in lieu of a CFIUS block include things like export controls, cybersecurity standards, the Foreign Agent Registration Act or FARA, and the FCC rules, the Federal Communication Commission's rules. So second, as I've mentioned before, and this point has some tension built into it that perhaps people would like to discuss a bit in Q&A, the CFIUS process has traditionally operated to really clearly focus on the uniqueness of each transaction before the committee and how that relates to national security. While certain investors are of more concern to the committee than others, each transaction receives its own threat assessment because the committee emphasizes the second part of this phrase, national security risk arising from the transaction when it conducts its review. Third, CFIUS has recently undergone some significant changes due to the 2018 passage and 2020 implementation of the Bipartisan Foreign Investment Risk Review and Modernization Act, or FIRMA. So first, while previously CFIUS was mainly focused on the US defense industrial base, and since 2007 also on critical infrastructure, CFIUS is now particularly concerned with transactions that implicate critical technology that may have dual use applications, and also on sensitive personal data businesses. FIRMA, along with focusing more on these types of businesses, also expands CFIUS jurisdiction to venture capital due to concerns that some investors, and here I should be clear that a lot of the concern was about Chinese-based investors, may have been skirting CFIUS review by investing in tech startups. And as I mentioned before, there are also these new authorities over real estate investments that have co-location issues. FIRMA also enables CFIUS to engage in more information sharing about sensitive transactions and problematic parties with US allies. And it also creates a very limited sense of regulatory carve-outs for investors from a small set of accepted states. But this is a very small kind of group of investors that only get a little bit of relief when it comes to mandatory filings around critical technology, which I'll explain in just a minute. So probably most importantly, FIRMA has transformed CFIUS from a mostly voluntary process to one that is increasingly mandatory. In contrast to other countries that have sectoral specific but mandatory screening, CFIUS has really broad cross-sectoral authority, but firms generally engage with the committee on a voluntary basis. You might ask, why would a firm do that? Well, the incentive is that CFIUS provides cleared transactions with safe harbor, which is really a wonderful thing for a firm to receive, because it means that the government cannot retroactively require divestment or impose other restrictions on cleared transactions. In many other countries, firms that get authorized to move forward don't receive this kind of legal safe harbor. So this is a big deal to receive safe harbor, and it really motivates some firms to go ahead and move through the filing process. But FIRMA has made a subset of transactions subject to mandatory filings. These are mainly investments in critical technology businesses and transactions in which a foreign government-controlled entity obtains a substantial interest in a U.S. business. And the FIRMA also has been used to ramp up CFIUS's non-notified procedure, in which the U.S. government monitors non-notified transactions of interest and reaches out to parties to initiate post-closing review. Okay, so I'm actually a little bit over 15 minutes already. So I'm going to go through this slide a little bit quickly because I don't want to get too lost in the weeds, and I want to just give a bit of an overview of how you actually go through and file before we can wrap up and get to questions. So over here, I have sort of a flow chart that helps to determine, or helps someone determine, whether or not a transaction is covered through CFIUS and whether or not it is a covered voluntary filing or a covered mandatory filing. So basically, if you are engaged in a transaction, what you need to do is first determine if you're covered or not. And basically that is based off of, is this an instance in which a foreign entity is obtaining control over a U.S. business? If so, that's covered. If you're not gaining control, are you gaining some sort of special rights? And are those special rights in a U.S. business that meets the definition of a TID business? If so, you also are covered. And then if you are buying or leasing real estate that is covered through co-location, that would be a third way through which you would be covered. But not all covered transactions are required to file, so then you have to determine if you have an obligation to file, and that's based off of whether or not a foreign government-controlled entity is obtaining a substantial stake in the investment, and also if the investment, if the U.S. business is in a critical technology business, which normally has to do with export controls, and if you would need a export license in order to export the technology that is part of that U.S. business to the country in which the acquirer is based. And so once you determine if you're covered and if you have an obligation to file, if you have an obligation to file, then you just know that you need to file. But if you are in a voluntary kind of situation, then you need to think through if you should file, which is going to be a function of if you anticipate that your transaction could be considered to generate a national security risk. And then if you are filing, you need to determine if you should move forward with a full filing or through an expedited declaration process. And the basic idea here is that a full filing has a 45-day initial period with the possibility of a 45-day investigation. And now there is a fee structure for full filings. So some companies may worry that that's going to take a long time, going to make it harder to get to yes on their transaction. and so may decide to move through a declarations process, which is a shorter process, a shorter form. It's a 30-day process, and it's free. You do not need to pay a fee in order to declare, but you could get a request to file. So if you think that your investment is something that the U.S. government is going to have some concerns over, going through a declarations process may just tack on 30 days to the process. And once you actually go through and file, you submit forms through a secure portal on Treasury's website. As I mentioned before, I really recommend talking to an attorney with CFIUS expertise to decide whether you should file and through what means, because they will have a lot more to kind of share with you here on that point. So I have a conclusion slide that just overviews what I talked about, but at this point, I'm going to stop talking so that you all can start asking questions. Thank you very much.
Well, Ms. Bowerly Dansman, thank you so much for that detailed presentation. And bureaucracy and regulation is always very fascinating. So I guess the first question I wanted to pose to you is just to have a better understanding of what that national security risk is. Is it a test-based system? Is it a rules-based system? Is it just kind of this, opaque veil that's being used when it comes to the regulation part?
Yeah, that's a great question. So national security is not defined in statute. And so, and part of the reason for that is that there's an expectation that what counts as national security will change over time. And also because if you are too clear about what the national security risks might be, then it could make it easier for threat actors to evade those sort of strict definitions. And so, but that doesn't mean that national security means whatever the committee really wants it to mean, because of the fact that it is an interagency body. And so you might anticipate that certain agencies within CFIUS are going to be more kind of risk avoidant when it comes to accepting investment from other countries with actors that they think of as perhaps being threat actors, whereas other agencies are really focused more on kind of on commercial concerns and making sure that the business environment in the US is as open as possible. And so that sort of creates a lot of balancing on the committee to prevent it from going too far in a restrictive kind of frame. And so, as I mentioned before, normally, like in the past, CFIUS was really focused on things like, is this investment related to the US defense industrial base? And if so, how can we make sure that we can continue to get the components that we need for our military, and that those components we can be assured are, made to proper specification and that they're not tampered with in some way. And then also kind of concerns about critical infrastructure to prevent threat actors from gaining access to that critical infrastructure to shut it off or otherwise use it as a bargaining chip in kind of, in terms of competition between powers. But now there really is more focus on things like critical technology, and that is about trying to make sure that technology that the US government wants to keep controlled for national security reasons doesn't leak from the US company to, threat actors. And then also the sensitive personal data, that's very well defined in statute. So it's there's a few different ways that you can get to being considered a sensitive personal data company. But if you're collecting 1 million or more records that have personally identifying information, or if you're collecting a smaller amount of data that is kind of health data, that reaches the level of concern. And that's more about privacy protection and so forth. So, there are, so I wish that I had a clear answer of like, this counts as national security and this doesn't. But I think that from a firm perspective, it's easier to sort of assess, do you think that your business, the target business, has a component of it that is of concern, that might be considered a vulnerability to the US, that's easier to determine than if it's a national security risk, because the national security risk is based off of the threat actor, right? Is there a threat actor involved in the transaction? What is the vulnerability to national security of the US-based firm? And how does that threat actor and the vulnerability interrelate? And that's a little bit harder to sort of totally understand, ex ante.
Well, thank you for that. We have a question here from Chiang Zhang, who asks, what were some of the typical investments that were reviewed in the past? If you have any examples in terms of the types of industries, the dollar amounts, and the others.
Okay, thank you. Yes, so if you go to if you just Google, if you go to the U.S. Treasury's website and then look at their page on CFIUS, Treasury does release a annual report on CFIUS in which it provides information about the country of origin of filers, as well as the industry of filers. It doesn't provide information on the exact transactions because that is confidential information. But that can help you see that, that there's, that in the past, there have been a lot of filings around critical infrastructure, especially things related to telecommunications and the electric grid and so forth. And increasingly, there have been more filings around critical technology. But one of the things that I would caution there is that the 2018 FIRMA change really kind of gave firms a lot more information about the types of investments that CFIUS was really concerned about, and so kind of what you see prior to that going through and what you see now is going to be quite different because, again, most of the filings are voluntary, so firms are making decisions about whether they think that their transaction might have national security implications, and really only filing if they think that the government might be concerned about it, because they don't want to have a post-closing review, because then they might have to divest, and that is a terrible option, right? So in the past, we've seen, more focus on critical infrastructure. That will continue, but critical technology and sensitive personal data companies are definitely becoming a larger portion of investments that are being reviewed. And then in terms of size, CFIUS does not have a size threshold, and so these can be very large transactions as well as very small transactions. And the movement towards also including venture capital also pushes the kind of standard or the average size of a transaction being filed downward, just because now you don't have to be a large publicly traded company to make it to